Good evening, guys. I am Raven Carlos Cubalida, and I am here to discuss to you the topic that is all about the purpose of speedy trial. According to the 1987 Constitution of the Philippines, under Article 3 Bill of Rights, specifically the Section 16, wherein all persons shall have the right to a speedy disposition of their cases before all either judicial, quasi-judicial, or administrative bodies. The right of the accused to a speedy trial and to a speedy disposition of the cases against him was designed to prevent the oppression of the citizen by holding criminal prosecution suspended over him for an indefinite time and to prevent delays in the administration of justice by mandating the courts to proceed with the reasonable dispatch in the trial of criminal cases. Such right to a speedy trial and a speedy disposition of cases is violated only when the proceeding is attended by vexatious, capricious, or oppressive delays. The inquiry as to whether or not an accused has been denied such right is not susceptible by precise qualification. The concept of a speedy disposition is a relative term and must necessarily be a flexible concept. While justice is administered with dispatch, the essential ingredient is orderly, expeditious, and not mere speed. It cannot be definitely said how long is too long in a system where justice is supposed to be swift but deliberate. It is consistent with delays and depends upon circumstances. It is secures rights to the accused, but it does not preclude the rights of public justice. Also, it must be borne in mind that the right given to the accused by the Constitution and the rules of court are shields, not weapons. Hence, courts are to give meaning to that intent. The right to speedy disposition of cases is violated only when there is inordinate delay, such that proceedings are attended by vexatious, again, capricious and oppressive delays, or when an unjustified postponements of the trial are asked for and secured, or when without cause or unjustifiable motive, a long period of time is allowed to elapse without the party having his case tried. What we call this is the inordinate delay was first introduced in Tatad versus Sandigan Bayan. In Tatad, this court ruled that the inordinate delay in the conclusion of preliminary investigation and subsequent filing of information will result to the violation of the right to a speedy disposition of cases and right to due process. In so ruling, this court considered several circumstances such as number one, the political motivation which propelled the prosecution. Number two, the patent violation of procedural rules. And number three, the unjustified delay attending the investigation. Ultimately, Tatad held that the determination of whether or not there is violation of speedy disposition of cases applies on a case-to-case basis. In a number of cases, this court has not hesitated to grant the so-called radical belief and to spare the accused from undergoing the rigorous and expense of full-blown trial where it is clear that has been deprived of due process of law or other constitutionally guaranteed rights. Of course, it goes without saying that in the application of the doctrine enunciated in those cases, particularly regard must be taken of the facts and circumstances peculiar to each case. Thus, the concept of speedy disposition is relative. There is no hard and fast mathematical rule on the reckoning of time involved, and facts peculiar to each case must be taken into account. Nevertheless, this court carved a standard in test in resolving these cases. Martin V. Burr adopted the balancing test, which provides four factors as its guide in determining the existence of inordinate delay. Namely, number one, the length of delay. Number two, the reason for delay. Number three, defendant's assertion to, or non-assertion assertion of his right or her right. And number four, prejudice caused to the defendant is as a result of the delay. However, these factors must be taken into account together with the other circumstances of the cases. Furthermore, the totality of the facts must be weighed and evaluated. In determining the length of delay, Dansal versus Hernandez recognized that the period must include the investigation even before the trial commenced. In criminal prosecutions, rules on preliminary investigation under Rule 112, specifically the Section 3 of the Rules of Court, come to play. Section 1 of the Republic Act number 8493, otherwise known as the Speedy Trial Act, also laid down the time limit of 180 days for the entire trial. The guidelines for decongesting holding jails by enforcing the right of the accused bail and to speedy trial likewise provide for strict time limits that must be observed, among other laws. In cases filed before quasi-judicial agencies, there is no law for the period to be observed in terms of disposition of the case. In cases before the Office of the Ombudsman, um, the Constitution only mandates it to act promptly on cases as observed in Kagang versus Sandigan Bayan. So, uh, that is all. I'm thinking.